And so she is stating she wasn't ready, but I let her know that we needed to proceed.
Okay, proceed with the withdrawal?
Well, she would like us to proceed with the withdrawal. I told her that if it's not granted by the court, we will proceed with the hearing.
Okay, yeah, I don't see that on the computer yet.
Correct. Right.
Okay.
I let her know it has not been accepted by the court. I'm just letting you know because I'm sure she will bring it up again. And so just letting you know.
Okay. Yeah,
Other
and
than
it
that,
hasn't, it hasn't even been
accepted.
Right out of the gate, we've got procedural tension. A motion to withdraw is already in play, and the court hasn't fully processed it yet. That might sound minor, but timing here is everything. If the withdrawal isn't properly granted, the attorney is still on the hook. So the question becomes, is this a clean exit, or the start of confusion?
I do see it accepted now.
Oh.
I don't see where you actually sent her notice of it.
Notice of the withdrawal?
Yes. So if you were wanting
Understood.
to withdraw for today, you would have had to send her like the 10-day letter.
Correct,
or
Your
she
Honor.
could have signed the order and we would have signed it that way.
She did sign it, Your Honor. It was
The
an agreed
proposed order?
She signed the agreed withdrawal. I'm sorry, the order. I'm not even seeing that in the system.
I see the order attached to the back of the motion. And I do see where she signed it. So are you wanting to proceed today and then I just sign it afterward?
Your Honor, I don't, based on what my client said, no. If Your Honor does not grant it, I'm ready to proceed, Your Honor. I just know that that is the first thing she's going to bring up. And I know. So she wants the withdrawal to be granted.
Well, if she wants the withdrawal to be granted, then she has to be here to proceed. Well, not necessarily. We could still proceed in her absence. The court is not. Is she here?
She should be. She should be in the waiting room, Your Honor.
Let me see. Okay. Oh, there she is.
Do we have Jim Cobb here as well? I know he was subpoenaed.
Mm-hmm.
I don't see him yet.
Okay.
Good morning.
Good morning.
Okay. Miss Brown. Miss Brown, can you hear me?
And here's where things get uncomfortable. The court is drawing a hard line on courtroom procedure versus personal accommodation. Now, legally speaking, accommodations usually need to be documented before the hearing, not raised in the moment. But emotionally? You can feel the tension building. One side is asking for sensitivity, the other is enforcing structure. And neither is backing down.
I can hear you, ma'am.
Okay, you'll have to turn your camera on too.
Okay, I asked for a PTSD accommodation because
and I denied it. So could you turn your camera on, please?
Okay, I'll turn it on for a little bit. Yes.
No, you will turn it on for the duration. You do not get to decide how long you keep your camera on.
Okay. Well, ma'am, I have accommodation by the Disability Act, and I have PTSD related to domestic violence by Mr. Brown. So for me, it's a trigger, and I asked for accommodation.
That is not before me. I don't have anything from any doctor or anyone saying.
Okay, I have the paper. We can provide it to you, the lawyer.
You did not provide it to me before today, ma'am. So you will keep your camera on.
Okay.
Just don't look at him.
Okay.
Okay.
This is a turning point, and honestly, a risky one. She's being forced into a split-second decision: keep the lawyer or go solo. And choosing to represent yourself in a live hearing like this? That's like stepping into a professional arena without training. The court's moving forward no matter what, so the real question is she prepared for what comes next?
So we have a preliminary issue we need to take up. There's a motion to withdraw on file.
Right.
And your attorney informed me that you would like for her to withdraw.
Yes.
If that's the case, then you're proceeding on today's hearing by yourself?
No, I do not have a legal representation today. I would like to resolve it and ask for continuous.
Okay, so that's not how it works. We're here today. So you have two options. You can either allow your attorney to proceed with the hearing today, or I can allow her to withdraw as you have requested, and you can proceed by yourself.
I cannot proceed. I cannot proceed because I do not, English is my second language, and I do not have, any knowledge and understanding of legal terminology. So I would need to have Hebrew interpreter.
Okay, so we're not doing that because, like I said, we are here today. So either you allow your attorney to proceed or you can proceed. Those are your options.
I do not.
Okay, so your attorney is proceeding.
No, I do not allow it to proceed. I withdraw my
attorney. I'll withdraw her.
Okay.
And then you can just stay online or you can leave, but the hearing is going to proceed either way.
Okay, you can continue. Go ahead.
Okay. All sides ready to proceed? Wait a minute. I want Attorney Ukwamo. I'm going to go on the record, and we're going to, after you announce, I'm going to let it be known that I am signing the motion to withdraw to allow you to get off the case, and then you can drop off the call.
Yes, Your Honor. Thank you.
You're welcome. You ready, Joey? All right. We're on the record and calls number DF2514654. Counsels, will you please announce for the record?
Haley Doyle, attorney for movant Marvin Brown.
Good morning, Your Honor. God is Ike Ukwama on behalf of Michelle Brown, who is present.
Okay. With those who intend to testify, please raise your right hands. Okay, Ms. Brown, are you going to raise your hand? All right. Do you both swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes.
Thank you. You may lower your hands. Prior to going on the record, there was some discussion about a motion for withdrawal of counsel filed by Attorney Ukwama.
Listen carefully to what the judge just said. Same standards as any attorney. That's not just a formality. That means rules of evidence, proper objections, courtroom procedure, all of it. No shortcuts. This is where many self-represented litigants struggle, not because their story isn't compelling, but because the system demands precision, not just passion.
In regards to the representation of Michelle Brown, the court has reviewed the motion, and attached to the motion is an agreed order signed by Ms. Brown. So the court is going to go ahead and sign the order for withdrawal, allowing Attorney Ukwama to get off of the case as well as drop off the call for today's hearing. And Ms. Brown is going to proceed with this hearing on her own if she so chooses. Okay?
Thank you, Your Honor. May it be excused?
Yes, you may. Thank you. Have a good day.
Thank you. You too. Thank you.
You're welcome. Thank you. All right. The remainder of the case that we're on here today is for a bill of review, and it was brought by Mr. Brown by way of his attorney, Ms. Doyle. You each will have 15 minutes aside that will include any opening and closing statements should you all choose to make them. Prior to going on the record, there was some exhibits that were pre-admitted. They will be admitted at this time. So petitioners exhibits 1 through 5, number 13, and numbers 15 through 17 are admitted, and respondents exhibits 1 through 7 are admitted. Ms. Brown, since you are representing yourself, you are held to the same standards as any attorney. If an objection is made, you have to stop speaking. You can call any witnesses that you may have, including yourself. You may be your only witness. Or you can call Mr. Brown, and you're also able to cross-examine Mr. Brown about any testimony that he will give. Attorney Doyle, would you like to make an opening statement at this time?
No openings, Your Honor.
All right. Ms. Brown, would you like to make an opening statement at this time?
No.
All right. Attorney Doyle, you may call your first witness.
Judge, I call Marvin Brown.
All right. You may proceed.
Thank you, Judge. All right, Mr. Brown, can you go ahead and just state your full name for the record?
Marvin Brown,
Alrighty, and where do you currently reside?
in France.
Okay, and where were you living in November of 2024 when Michelle filed the original petition for divorce here in Dallas?
In France.
Okay, and how long had you been residing in France at that time?
Off and on since 2013. We have lived in. Okay. I can tell you other places if you need it.
No, that's okay. So at the time that the original petition for divorce was filed in November of 2024, how long had you been living in France for an extended period of time?
When was COVID?
Yeah, 2020.
Okay, so I would say since 2021, 2022.
Okay. Alrighty. And so do you have the exhibits pulled up?
Yes, I do.
Okay, if you can take a look at exhibit 15 that's been admitted, is that your current residence listed on that envelope?
No, it's not.
All right, what is that residence?
That is that represents the lake house I used to live in.
Okay, and when did you live at that address?
In 2025, I believe this one.
Okay, and so is that where you were living?
I think it's either the summer of 2024. Yeah, I will say the summer of 2024.
Okay. All right, and so is that the address that you were living at while the divorce case was pending here in Dallas?
Yes.
Okay. And so was Michelle aware that you were living at that residence?
Yes, she's on the lease.
Okay, Michelle was on the lease at that residence. Okay. And so was Michelle also living at that address or was she living somewhere else?
She lived at that address till probably like for 6 months, I would say.
Okay. Okay.
And then
But
she moved to Paris.
Okay, but she was aware that that is where you were residing, correct?
Oh, yeah.
Okay. And you said she had moved to Paris?
Yes.
Okay, when did she move there?
And also another town up towards, what's it called? Normandy, up near Normandy, yeah.
Okay, and when was she living there?
Oh, gosh. Around Christmas and New Year's of 2025.
Okay, and can you take a look at Exhibit 5 for me, please? And that is Michelle's pay stub. And in the top left corner there where it shows her address, is that the address that she lived at in France?
Yes, it is.
Okay. And to your knowledge, when was the last time she was residing at that French address?
We moved from there to the lake house.
Okay.
To the house in Montferrat where that EDF bill is at.
Okay. And were the children always residing with mom during this time?
No, they were not always residing with mom.
Okay, where were the children residing at this time?
With both of us, we were together.
Okay, and so...
Whoa, this is a classic courtroom misfire. Instead of making a clear legal objection, she launches into a full narrative. And here's the problem. Courts don't respond to stories in the middle of testimony, they respond to legal grounds. So while what she's saying might feel important, procedurally, it's not landing where it needs to.
After you separated, where did Michelle and the children reside?
The children lived with me.
Okay. All right, and so were you ever...
The children lived with me at the lake house until when they were taken out of school.
Okay, and when were they taken out of school?
The summer of 2025.
Okay, where were they enrolled in school?
Your Honor, objection?
Okay.
Objection?
Okay.
Yes.
What is your legal objection?
We all three of us are victim of domestic violence. They were not taken out of school. Eleanor were abused by Mr. Brown, and I rescued her in May of 2025. And then I rescued Sabrina and brought him back to America, to the United States. And I never lived in that address. On every address that you see in this hearing is address that I never really lived in it. The thing is, Mr. Brown is not legal in France. Mr. Brown was able to stay in France because I am a French citizen, and every bill has to be on my name because I am a lawful resident and citizen of France. So by default, every address you see will have my name, nothing with his name because he's not legal in France. He's currently not even legal in France and has proceeding and have, police reports pending for Mr. Brown because he's not willing to disclose his address. They're looking for him. So objection for everything he says right now.
Okay, so what is your legal objection?
My legal objection is that the girls were not with him, were not taken from him. They were rescued by him because of domestic violence. And that's part of my case. My case is about domestic violence.
Okay, I'm going to overrule the objection. Counsel, you may proceed.
Thank you, Judge. Okay, Mr. Brown. Were you ever personally served with a divorce petition filed in Texas?
Personally served. Okay.
Yes. Did anyone ever come to you in person and serve you with divorce papers?
No one personally
Your Honor,
served.
objection. Your Honor, objection.
Okay, what is your legal objection?
In 2023, I've notified Mr. Brown that I will file for divorce in Dallas, and Mr. Brown was not cooperating. This is the reason why I had no other choice but to run from him, run from home, and get to America and file in America. I was scared to death, and he did not cooperate with any proceeding. He blocked therapy for my daughters, and he would not allow us to have any of his addresses. He would block my phone. He would block his phone. He would control my emails, and he will never, ever, and told me he would not proceed with anything related to the divorce. So he knew very well that I'm going to the United States of America to divorce because this is where we lived pretty much all our life, and would not cooperate with the proceeding.
Okay, thank you, Ms. Brown. What is your legal objection?
My legal objection is that Mr. Brown was notified by me.
Okay.
That I will divorce him in the United States. He knew very well.
Okay, overrule.
Okay, Mr. Brown.
Yes.
Did you receive any documents by certified mail, email, or were you otherwise notified of a Texas divorce case pending against you?
Texas divorce case pending. No.
Okay. And you did learn that a default decree was entered, correct?
Correct.
When did you learn about that?
2 days before I was to have the French court hear about the divorce.
Okay. Do you remember about what date that was?
Oh gosh. It was in July of 2025, I believe it was.
Man, by July, objection, by July I was divorced.
Okay, what's your legal objection?
A legal objection is in July 2025, I was divorced.
Okay, overrule.
Continue.
Counsel, you can re-ask your question.
Okay. Mr. Brown, what was the date that you had first learned that a Texas divorce case even occurred and was defaulted against you?
Gosh. Can you give me 2 minutes? I can look it up right fast.
No. It was July 20, about when you said July 2025, about when you learned about it?
Yes, June or July.
Okay. Alrighty. And how did you learn about it?
From my French attorney.
Okay. Do you have any idea how your French attorney came to be aware of the Dallas divorce decree?
Michelle's French attorney. sent my French attorney an email.
Okay. Okay. And so Michelle did know where you were living in France at the time the default divorce decree was entered, correct?
Yes.
Okay. Did you communicate with Michelle during the time between November of 2024 and about June of 2025 when the divorce was pending in Texas?
Yes.
Okay. So what methods did you use to communicate with her? Was it through email, text message, phone calls?
I believe we lived together at the lake house at that time. Also, there's some emails.
Okay. And so your email address was known to Michelle?
Yes.
And she has contacted you at that email address around the time the divorce was filed, correct?
Yes.
Okay.
Objection.
All right. What is your legal objection?
Yes. My objection is I did not live with Mr. Brown at the time he just, mentioned. I ran away from home in October of 2024.
Okay. So what is your legal objection?
That I was not living with Mr. Brown.
All right.
Okay, Mr. Brown, if you could just quickly take a look at Exhibit 4 and also Exhibit 16. Are those email communications between you and Michelle?
Yes.
Okay. And so have you changed your email since those communications?
No.
Okay. And I'll direct you to Exhibit 2, which is Michelle's affidavit of diligent search. In that affidavit, she states that the last known address she has for you is a Farmers Branch, Texas address. Have you ever lived in Farmers Branch, Texas?
Yes.
Okay, when did you live there?
I'm going to say 2013.
Okay. So the last time that you resided in Farmers Branch, Texas was 2013, correct?
Correct.
Okay. And so does Michelle have knowledge of when you left Farmers Branch?
Yes.
Okay. And does she have knowledge of where you moved to after leaving Farmers Branch?
Yes.
Okay. She also stated in the affidavit that you left in February of 2023 and she hadn't heard from you since then. Is that true?
No.
Okay.
Objection. Mr. Brown was arrested in France, in Paris, and was now allowed to be near my home for about 3 months. So yes, for 3 months, we did not see him. He disappeared. He broke his parole, actually. He broke his probation and came to the house and took his bicycle. And I was filing for another complaint to the police so he can stay out. But for 3 months, you're not allowed to be anywhere near my home.
Okay. So what is your legal objection?
My legal objection is Mr. Brown, on those 2 months or 3 months, was not anywhere near my home.
Okay. Overrule.
Okay. And Mr. Brown, in fact, she had heard from you since February of 2023 because she emailed you, as shown in Exhibits 4 and 16. I just want you to confirm of March 2024 and January of 2025. Is that correct?
Correct.
Okay. And so at the time this petition was filed, November of 2024, were you a resident of Texas?
No, I was not.
Where had you been residing for the 6
France.
months prior to November of 2024?
France.
Okay. And are you aware of where Michelle was living 6 months prior to November of 2024?
France.
Okay.
Yes.
And where were the children living in the 6
With
months
me,
prior to
France.
November 2024?
Yes. France.
Okay. And were there any ongoing legal proceedings in France involving your marriage or your children?
Yes.
Okay. And so when was the French case opened?
2024.
Okay.
Actually, if you go back to, I think, 2023, it was originally open, then it was suspended, with the ability to have it reopened.
Okay, let me ask you this. Can you take a look at Exhibit 17? And that's the agreement between yourself and your French attorney, is that correct?
Correct.
All right, and you signed that agreement in December of 2023, is that correct?
Correct.
And in fact, on page 2 of Exhibit 17, can you just read to me the first sentence under Article 1?
The client has asked the advocate to advise, assist, and represent him in a divorce proceeding issued by Madame Michal Ben Moshe in Paris, France.
And can you just, for clarity, let the court know who Michal Ben Moshe is?
Michelle Brown.
Okay. All right, and so if you had known about the divorce case here in Texas, would you have appeared?
Remotely, yes.
Would you at least have filed an answer with the court in an effort to not be defaulted?
Oh, yes, definitely.
Okay. And what defenses or objections, if any, would you have raised at that time?
Oh, that she's not a resident.
Okay. And that you also are not a resident, isn't that correct?
Correct. And
Okay.
the kids aren't a resident either. No one's a resident of Texas.
Okay. And so are you asking the court today to vacate the final decree due to both insufficient service and a lack of jurisdiction?
Correct.
Okay. And was it necessary for you to retain myself and Mark Saltman and Johnson to bring this case before the court today?
Correct.
And through retaining our firm, did you incur attorney's fees?
Yes, I did.
And were those attorney's fees in the amount of $3,000?
And this is the credibility crossroads. The judge is essentially saying, you can't selectively engage with the process. From a legal standpoint, consistency matters. If you demonstrate understanding at one moment and deny it the next, it raises red flags. At this stage, the judge isn't just into answers, she's evaluating reliability, control, and overall credibility.